UK, USA, tax talk and more from Collier Bristow. Welcome to the Collier Bristow series, UK, USA, brought to you by our tax and estate planning team. The series discusses a range of private wealth matters, all with a US flavour. In this latest episode, Senior Associate Aidan Grant is joined by Gillian Everall of Everfair Tax. Together they discuss the complex topic of living trusts, looking at why they are favoured by Americans, how they sit aside UK tax laws, and how the UK and US approach living trusts differently. We hope you enjoy the episode.
Welcome back, ladies and gentlemen, to Collier Bristow's US-UK podcast, a series designed to map out the complex world of transatlantic private wealth matters and provide you, if not with a detailed route map, then at least an A to Z of some nice sightseeing stops along the way. As ever, if you haven't listened to any of our previous episodes, please do go ahead and take a listen. They're probably very close to wherever you're listening to this episode. Today, we're looking at the topic of US living trusts, otherwise known as irrevocable trusts or grantor trusts, or if you're a tax advisor like me and my colleague today, an absolute pain in the neck. I have the privilege of being joined today by Gillian Everall, Everfair Tax. She's the founder and managing director, and Everfair are a sort of a dual qualified US-UK accountancy firm here in the UK. Gillian, it's an absolute pleasure to have you. Would you like to introduce yourself for the listeners?
Yeah, thanks for having me on, Aidan. Yes, for my sins, I've been doing this for more years than I care to remember. I think we might be talking about 22, 23 years now, and specialised for the last 8 years in supporting US citizens living in the UK. So I'm not sure at this point that there's much that hasn't been thrown at me. So hopefully I'll be able to answer the listeners' questions on this topic today and give them some tips that I've picked up over the years.
As listeners will know by now, I love a good hypothetical client, and today is no exception. So let me introduce you to Mr. and Mrs. Washington. And yes, I'm still doing US presidents. Mr. and Mrs. Washington are a wholly US-based couple with a US living trust that holds all of their worldly possessions. They have 2 children, a son in the US, let's call him George, and a daughter in the UK, let's call her Martha. I'm aware, by the way, for US historians that George and Martha Washington were a husband and wife, but they're a brother and sister here and nothing more, I'm afraid. Martha has come to us explaining that her parents have begun to discuss their estate planning, and she's aware they've got a living trust. Now, very fortunately, Martha remembers reading something in the papers about how the UK treat living trusts, and so she's come to see us today to ask more questions about what she can expect when her parents make gifts or leave inheritances to her during their lifetime or on their deaths. So in order to answer those questions, we're going to look at a couple of different topics. We're going to look at what living trusts are, why many Americans have them, and to that end, we will be covering some of the ground we discussed in my US-UK probate episode with my colleague James Cook. We're then going to look at why the US and UK potentially tax them very differently, and then what could be done about it, broadly speaking, if you find yourself with a living trust and want to sort of sand down some of those rough UK edges. Certainly from my experience, and I'm sure that Gillian would agree, it can often come as a shock to American estate planners that their careful trust planning can have a sting in the tail for UK tax purposes.
And that's absolutely right, Aidan. Not only does it come as a complete shock, but it feels grossly unfair as well that there really is increasingly a huge discrepancy between the way that the US regard these in terms of a fairly straightforward vanilla option for speeding up the probate process rather than a big complicated formal family settlement designed at directing and protecting wealth during the lifetime of the individual on the death of the individuals involved. So there really is discrepancy that, as you say, catches people hugely by surprise.
Yes, and it's important to pick up that point from Gillian. When we're talking about living trusts, we're not, for US purposes, we'll very much come on to the UK position, but for US purposes, these are a non-entity. These are an uninteresting, banal piece of estate planning that Americans use as a way to avoid title having to pass on death to the beneficiaries. Assets remain titled in the name of the trustees, and thus the need to go through the probate process, which for Americans is costly, arduous, and no one wants to go through. They're incredibly popular. the reason, Gillian, correct me if I'm wrong, the reason these are so particularly useful in America and people like using them is that they are entirely transparent for US tax purposes. The grantor of these trusts is treated as being beneficially entitled to all these assets. Any income or capital gains arising are taxed on them as an individual. And on their death, the sort of US estate tax treatment is the same as if they held these assets in their own name.
Yes, Aidan, that's absolutely right. These are nothing more than living wills from a US perspective. There's no intention that anything happens to the assets until death, and they're taxed in the exact same way. So you're absolutely right. The assets remain the responsibility of the person who created the arrangement and are taxed accordingly until they pass away.
And so they tend to come in two varieties. Certainly for me as UK tax advisor, Gillian, you may have a broader scope of clientele, a broader stable, if you will. From my experience, I find they most frequently come up in two scenarios. Firstly, the Washington's scenario here, i.e. a couple in the US have a wholly US-focused estate plan because their life, their money, their wealth, their history is in the US, but one of their children happens to have had the misfortune from a tax perspective to move to the UK, and now suddenly there is a UK nexus to their US estate planning. And so we need to consider the incidental UK tax treatment of a living trust because we need to slot that tax advice into the existing estate plan in the US. Or perhaps the larger challenge is where the grantor themselves comes to the UK, and now we have what we would consider possibly in the UK as a UK settlor of this trust, and that really does can drive a horse and cart through the estate planning because we now have not just a beneficiary but possibly the settlor and even maybe a trustee in the UK. Are those sort of from your perspective, Gillian, two of the most common scenarios, or are there other scenarios where you find living trusts?
No, I think that really covers the vast majority of circumstances, Aidan, where we come up against these type of arrangements and as you say, have to start really thinking through the interaction of the US treatment and the UK treatment. So yes, the fun, so to speak, definitely very much starts when either a beneficiary comes to the UK or if the grantor themselves, especially as you highlight, where they, as is quite often the case, want to be a trustee, then we get all sorts of things that we need to think about and work with the client to minimise the impact for them. And at the end of the day, to be honest, that's what it's about. None of this is insurmountable. It's about being aware of the considerations and how to plan for them and what you can do to mitigate the worst of any implications that might arise.
Absolutely. No one sets these things up wanting to create a greater tax headache for themselves, putting aside the estate planning and the probate concerns. People generally want to be tax conscious when they carry out their estate planning. And so no one would want to give themselves a tax liability, and particularly no one would want to give their children a tax liability. There's carrying out estate planning for yourself in the US, full well in the knowledge that your child's going to get an absolute kicker when they come to receive their inheritance in the UK would be probably not within many people's contemplation when they create their estate plan, not unless they're feeling particularly capricious.
I was just going to wholeheartedly agree, Aidan. I think it's really not a lot more than thinking, I really would like to do something that means they don't have to wait 6, 9, 12 months to be able to access any of my hard-earned wealth that I've developed over the years. I'd quite like them to get it, A, sooner than that, and B, without horrendous probate fees that they have to pay before anything can happen, really, especially in that lovely state called California.
Yes, and we will come on shortly to the different treatment by some of the different states because that also can affect our analysis here in the UK, which takes us very nicely onto this next topic, which is what is the UK's approach and particularly how does it differ from the US's? And it's probably important to start at the beginning of this section by explaining in a little more technical detail what we mean by living trusts, because it is a US structure. It is characterized by US provisions and by US law, and then it's about the UK trying to pigeonhole this structure and say, well, what does it look like for our purposes? How can we tax it? So commonly, living trusts have to have one of several key characteristics and usually have most of these characteristics. Gillian, stop me at any point if anything's wrong or you want to add. The trust has to be irrevocable. If it is an irrevocable trust, if the grantor cannot take the assets back, my understanding is it can't be a grantor trust. Secondly, the settlor is often a trustee themselves. They might be a sole trustee or they might be a trustee with another individual, a family member or an advisor. And then the income and capital generation during the lifetime of the grantor of the settlor typically is owed automatically to the grantor. If not by right, then they have some ability to demand or request it, or the trustees are under an obligation to pay out those monies quite liberally. Is that right, Gillian?
That is absolutely right, Aidan. What we find arises quite commonly is there is an absolute entitlement to the income with the best will in the world as far as the grantor is concerned. These are still their assets. They want to act, behave, and access these assets in the same way they did before the arrangement was put in place. So yeah, you're absolutely right. The vast majority of the arrangements that we see are revocable, allowing them to be wound up at any point. They do have an absolute right to the income or the ability to request it without the discretion of the trustees. Often, as you say, to add to that, they are trustees themselves. Grantor trust status from a US tax perspective all just goes back to the powers that the individual grantor creating the arrangement, funding the arrangement, keeps over the assets that they place within it. So there's a raft of powers that can be kept by the grantor that would make this a grantor trust. It's not exclusively linked that if it's irrevocable, it can't be a grantor trust, but it is a lot more challenging for it to be a grantor trust if it is irrevocable. So from their point of view, it's a nothing. And then we get the UK perspective, which is a lot more complicated.
So in the UK, we also have very different types of trust, and different trusts have different tax treatments. But before we look at the tax treatments, let's consider those different forms of trust. And for the purposes of looking at grantor trusts, you can put trusts into two broad categories. Some trusts in the UK, which I'm going to refer to in this discussion as a substantive trust, are what we think about when we think of trusts. It has trustees. The trustees hold assets. They hold assets for possibly a class of beneficiaries. It could be a discretionary class of beneficiaries. It could be holding assets for an individual until they reach a certain age or upon the ascertainment of a certain condition. Substantive trust here, what most people think of as trusts. But the concept of trusts in UK law goes much deeper throughout history than the last few decades. These are centuries old, these concepts. And trusts are created in English law and English society much more frequently than people realise. And often a trust is nothing more than a nominee arrangement where I'm holding something for Gillian. That's all I'm really doing. I'm just holding something for Gillian. And there's no real sort of structure to the arrangement more than that. In law, we refer to that as a bear trust in the UK. It's sometimes considered, like I said, a nominee arrangement. Bear trusts can be created in all manner of circumstances, but really just are created where one person holds something for someone else. They have an absolute entitlement to it as the beneficiary. They can claw it back at any time, and there are no other strings attached to them. And so the question will be, and leading the conversation this way, how does the UK view these grantor trusts? Are grantor trusts substantive trusts, or are they more like what the Americans would consider, which is a bear trust? They're looked through, they're transparent, they're revocable, they're not even really a trust at all. That is the nub of the issue, and that is where many hours of time get spent by people like Gillian and me trying to explain to clients. Gillian, where do you like to start with clients in terms of broaching this topic and starting to lay down some of the sort of the pros and cons as to how we divide up that analysis?
You've hit, I think, the absolute $1 million question there, Aidan. If you'd have asked me this question, how do the UK regard these arrangements? Do they fall within the bear trust or substantive trust category? Oh, I don't know, maybe 5, 6, 7 years ago. And bear in mind, this is something that has been a consideration, and these arrangements have been common part of US estate planning that people do, US citizens and US residents do for a large number of years, more than I've been in practice, scarily enough. If you'd have asked me previously, I would have wholeheartedly said bear trust, but more recently, there's been a real shift in the HMRC's view towards them being much more substantive in nature. No one's quite sure what's driven that change of direction, but it's becoming increasingly clear. And to go back to your question of, well, how do you approach this with clients who are either the beneficiary or the grantor from this perspective? You have to start with painting the picture and the understanding of HMRC's view. Long gone are the days where you could write to HMRC's trust division and get their kind confirmation they were happy for these to be considered bare trusts in all tax reporting, and any kind of planning that was being undertaken, you could disregard the trust arrangement. Long gone are those days. So really clients are left with Hobson's choice, if I may call it that. They can accept that these are substantive trusts in accordance with sort of HMRC's increasingly stated view, or they can take a more pragmatic approach, and we can talk to them about the possibility of continuing to treat them as bare trusts. As in all honesty, if you look at the intent behind the vast majority of these arrangements, they are with full disclosure to HMRC and considering the risks involved with that approach, with full understanding that if HMRC query that, what kind of a process and outcome that might lead to.
Absolutely. And we will come on to think about HMRC's hardening stance to this and what that means for the tax in a little bit. In terms of the dutiful listener who is listening ardently to this podcast episode and has pulled out their parents' copy of the Living Trust Deed from their records, is now furiously scanning through, let's be honest, it's probably 50 or 60 pages, knowing how long some US trust documents are, they're going, right, this is all in legalese and I don't understand. And tell me which of the provisions is the one that I should be turning to so that I can start to sort of work these things out. There is no silver bullet that describes, if you see that absolutely means this will be a bare trust. From my experience, and by all means, please do overrule me, Gillian.
I'd never do that, Aidan.
It's a lot easier to find the silver bullet that unfortunately says, no, that's a substantive trust, because you basically have to get through all of the traffic lights green for it to be a bare trust. And if any one of them turns red for you, then you're probably in substantive trust territory. And if we think about what those traffic lights are, if the trust is irrevocable, it's going to be quite hard to convince HMRC that it's a bare trust. If the trustees owe obligations or duties to anyone other than the settlor, so if there's a class of beneficiaries that can be benefited other than the settlor, if the trustee says, the trustees may take the balance of the income and distribute to such of other beneficiaries as they see fit, well, then you don't owe the obligations just to the settlor because you have other beneficiaries that you can distribute to. And even sometimes we've had discussions here at Collier Bristow between the interpretation of specific words. So sometimes when we talk about, let's say, the income that arises to a trust, one trustee might say that the settlor, the grantor, can request income from the trustees, and another trustee might say that the settlor can demand income from the trustees, and about whether demand is a more irrebuttable obligation than request is, because a request can be denied, whereas a demand can't be. So it really does come down, from my experience, to the minutiae of the trust deed. But would you agree, Gillian, that it's unfortunately, and we'll explain why it's unfortunate in a little bit, it's unfortunately easier to tip over into the substantive trust territory and be confident that we're in that territory than be able to say with complete confidence that, yes, this is a bare trust, and so we can take a slightly more relaxed view of the tax consequences?
I would wholeheartedly agree with that, Aidan. The practical experience of talking to HMRC about these arrangements and trying to generate a clear understanding of why people do them, create them from a US tax perspective. They've very helpfully perhaps sort of pointed in a number of specific circumstances, as you say, to the things that make them substantive from their perspective, but they certainly will not, and I don't think will, now provide sort of indications as to what you need to do to make them bare trust from their perspective. So it is an awful lot harder, and that's in part down to HMRC's perspective on things.
I imagine it's going to take someone going to court and challenging HMRC's opinion, and we need to get some High Court ruling or tax tribunal ruling as to the proper analysis of these things before we have a completely clear picture. And even then, it will depend, because whether something is a grant or trust can very much depend upon what point in its life cycle we're considering it. If the grantor is alive and well, then we might have one analysis. If the trust was dual settled by a husband and wife, let's say like Mr. and Mrs. Washington, well, what happens upon the death of one of the grantors? When there's a surviving grantor, are there sort of trickle down pour over trusts and other aspects which might make one or some of those trusts bare trusts but others not? And also what happens in scenarios like well, what if the grantor loses capacity? Because it's certainly the case in some grantor trustees that upon the grantor losing capacity, the trustees take over with a greater power to make benefits and gifts to other individuals because the grantor would have wanted to do so had they retained capacity. But that's counterproductive in the UK because the more power the trustees take from the grantor, the more likely we are to be in a substantive trust territory. So it's not even possible to say, in the absence of a timeline, does this trustee say that this is a bare trust or a substantive trust? We have to know at what point is the family. Are the grantors alive? Does the grantor have capacity, etc., Gillian? It makes it incredibly difficult.
No, you're right. You're absolutely right, Aidan. It does. It very much depends. If we ever get to a situation where we have a ruling from either the first tier tax tribunal, upper tier, or God forbid the appeal court, I would question the helpfulness on the basis that I would expect HMRC simply to come back and say, well, that's absolutely fine on that particular set of circumstances, but each case must be considered on its own merits, to coin one of their favourite phrases, a la other cases. And my favourite here is probably the Anson case on LLCs. They would do everything in their power to point to that being an anomaly and not something which can be widely applied in any way, shape or form.
So we've considered why Americans like grantor trusts, living trusts. We've considered why HMRC might look at them slightly differently, but that is merely the appetizer, the starter to the main course, which is, well, what does this all mean? So when we come back, Gillian and I will look at these issues. What are the tax consequences of having a living trust, and why might HMRC's insistence that it's a substantive trust be problematic for Martha Washington? See you in a little bit.
UK, USA, Tax Talk and More from Collier Bristow.
Welcome back, everyone, to Collier Bristow's US UK podcast. I'm still here with Gillian Everall of Everfair Tax, and today we're looking at US living trusts. Thus far, we've considered what they are, why Americans like them, and how the UK attempts to interpret them. We're going to move on now to look at the UK treatment of living trusts from a tax perspective and how that trust analysis can really impact on the extent to which UK tax is due. So, Gillian, in the previous part, you explained that HMRC has a hardening stance towards living trusts. And when we say a hardening stance, what we're thinking about is an increasing move to find these structures as being substantive. And it will come as no surprise to anyone that this hardening stance is towards the version of events that will give rise to more UK tax. It would be nice if they had a hardening stance towards less tax, but Kelsoprees know the hardening stance is towards more UK tax. So in the broadest of broad nutshells, because the taxation of offshore trusts is one of the most complicated areas of tax, if a living trust is considered a substantive trust, then it is with US resident trustees, as grantor trusts usually have, it is then an offshore trust for our purposes. It is a trust that is governed by various UK anti-avoidance rules that say if UK tax has not been paid on income and capital gains as they arise in the trust and have not been taxed upon the trustees because they're overseas, well then we're going to have those income and gains build up within the trust. And at some point, when a UK individual living, an individual resident in the UK, takes a distribution out of that trust or on any other kind of benefits, we're going to draw out some of those income and gains. We're going to tax you on them at that point. And that's problematic because you might have had tax at one point in the US on the trustees or on the grantor. You might have had tax in the UK on a distribution, but because of the time difference or because of the difference in taxpayers, you often don't get a credit for the tax paid in the US. And even the scant few reliefs offered by the double tax treaty between the US and the UK don't always help. That is about as brief analysis as I can give of offshore trusts. Gillian, is there anything else you would say is really important to know at a high level?
No, I think that's the nuts and bolts. Rather than having a nice, clean inheritance, as people are more likely to expect, you've got a potential income tax charge with a lack of recognition for the US tax paid along the way, principally because if you think about it, the trust has paid the tax along the way, or the grantor has paid the tax along the way. You're now looking at a distribution often many, many years down the line, and where if everything had worked properly, credit might have been available if the distributions were happening on a more regular basis, because they often happen much, much, much later, we have a bit of a problem in getting foreign tax credit recognition for those taxes the poor old grantor has paid on their annual US tax return year in, year out. You also, this catches a lot of people by surprise, you don't get the natural step up in basis for capital gains tax. So when it comes to divvying those assets out between the beneficiaries on passing of the grantor, they get a capital gains tax impact that they weren't expecting. And it's not just the case that they're only responsible for increases in value from when they actually receive the assets. There's a much greater potential sting in the tail, for want of a better word. Now, all this can be mitigated with planning, which is why sort of awareness is really so important.
Yeah, absolutely. There is nothing that's more frustrating or upsetting or annoying from a tax advisor is when you're asked to advise on the horse once it's already bolted out the stable door. Much better to deal with the horse while it's in the stable, to mix my idiom. So to sort of contextualize that with sort of some figures, what we're talking about is if a living trust is a substantive trust, then at worst, the UK beneficiary could be taxed at up to 45%, up to normal income tax rates on a distribution out of this trust on an inheritance. So let's say Martha, her parents, leave $1 million to her. She could be paying 45% on that $1 million in a way that her brother in the US would not be paying tax at all as a recipient, because he's not a UK resident. It can be possible to get that income tax charge down to a capital gains tax charge. That capital gains tax charge at current rates could be as high as 32%, but that's still 13% lower than an income tax charge. And when you bear in mind that it's possible that estate tax has been paid already in the US, you can end up with the take-home sum at the end of it being dramatically diminished as a result. Throw that over to a comparison to if this structure is a bare trust, it is a non-entity for UK tax purposes, like it is in the US, then Martha would in effect receive her inheritance from her parents as if her parents had given it to her directly. And in the US and the UK, death duties or gift tax in America, inheritance tax in the UK, these are all paid on the donor or on the estate. These are not paid by the recipient. And so Martha, if this trust is considered a bare trust, receives these assets free of tax. And so this analysis and HMRC's hardening stance towards living trust really is the difference sometimes between a tax charge of 45% on Martha and a tax charge of 0. That really does affect the cash in her pocket at the end of the day. And that's why it's really quite beneficial to go and take the advice beforehand, because as Gillian alluded to previously, it is much easier to do something about it while the grantor is alive and while there's the chance for further planning, rather than Mr. and Mrs. Washington had passed away and Martha now comes to us and says, I've just received $1 million. What is the tax consequence? Oh, Gillian, please help me report it, rather than what could I do? My parents want to give me $1 million in a year's time, let's say. That's right, Gillian.
That is absolutely right. And to add the cherry on the cake, this reporting is quite challenging. Again, as I say, you're often talking many, many years down the line. And who keeps records for sort of 10, 15, in some cases I've dealt with 20 years? So even establishing what the taxable amounts are from a UK perspective can cause all sorts of issues at a time that it's not easy for anyone anyway. So why you don't want this added headache and added professional costs of a UK US tax advisor such as myself to try and sort things out for you. If you can catch the situation when the beneficiary comes to the UK or ahead of the grantor wanting to come to the UK, then your life is made 1,000,000 times easier.
I don't know what cherries you're eating, Gillian, but that's not a very nice cherry. That's quite a sour cherry on the top of your cake.
It is a wholeheartedly sour cherry and very grim tasting sort of medicine to have to take.
Your point about record keeping is a really important one, because this is also the point where we frequently get asked about the interaction between lawyers and accountants. And I always find as a lawyer and a tax advisor, it's very easy for me to sit in my ivory tower and look at a trust deed and say, oh, well, I can pore over a trust deed and I can talk about legal analysis, interpretation and everything else. I'm fully aware that when it comes to the nuts and bolts of tax reporting, the matter very much has to go to accountants such as your good self, because it is you that has to do the forensics on the trust reporting and the trust accounts and say, where are the gains that you made in 2015? Or what about that income that you received in 2009? And as you say, if in America, they don't need to think about it because it's all just taxed on the grantor anyway, they would think, well, why we didn't need to keep records. Why are you expecting us to keep records? Out of interest, if people do find themselves in that position, what is your general approach with HMRC? If you hold your hands up and say, the records just simply don't exist, Do HMRC offer you sympathy and pity and say, well, that's absolutely fine. We'll take a very generous view of all of this? Or are they more likely to say, well, if you can't tell us, we're just going to tax you at the highest rate?
They certainly don't do the latter, Aidan. The reality is probably, as with many of these things, somewhere in between, and can vary from case to case, because unfortunately it can be down to the individual inspector that takes on the case and you have the discussion with as to what they're happy with. The key phrase here is reasonable efforts. You've got to make reasonable efforts to establish the tax liability. They do take a sympathetic view of not appreciating, because of a focus on the US tax position and it only being latterly that there were US issues to contend with. They do take a sympathetic view of that, in terms of they don't say, well, you should have known you had to keep all these records for all these years. And they just expect that you approach things in a just and reasonable manner with the information that is available. And perhaps the expectation would be that you err on the side of caution, in terms of perhaps if you're making an estimate, err on the side of it being an overestimate than an underestimate. Surprisingly enough, but other than that, they do appreciate, and they themselves, with the best will in the world, Aidan, as I'm sure anyone dealing with HMRC in any capacity will be aware, particularly in the current strange circumstances in which we continue to find ourselves, they don't have the resources to spend significant amounts of time going backwards and forwards with a taxpayer and their advisors to establish what was and was not available and what they should have done. So there is an opportunity that if the facts are presented to them in a clear manner where they get comfort that a reasonable effort has been made, they are much happier to just accept that and move forward. So again, communication with the revenue at the earliest opportunity and with as much clarity on the situation and as much context of the situation as can be provided can be really, really useful.
Which takes me to two, I think, points of note. One is presumably that record keeping and that record ascertaining is presumably a lot easier while the grantor is alive, because if it's the grantor's asset, if the grantor's a trustee in particular, finding out that information is going to be a lot easier when that person's alive than trying to go back to their records when they're dead. So we will come on in a little bit the final section on sort of what can be done about this, particularly what can be done while the grantor is alive. One of the things that could be done is build up your records while the person whose assets these are effectively in the US is alive. Ask them, go through it with them. Don't wait until after they've died to then think, oh damn, we should have kept some records. The other thing in terms of reporting to HMRC, this is one of the points the paradoxes I've always struggled with, is if this is a substantive trust and a UK resident beneficiary receives a distribution out of it, they are obliged to report that on their self-assessment tax return here in the UK. If this is a bare trust, then correct me if I'm wrong, but they're not obliged to report anything, because you aren't obliged to report gifts in the UK, like similar to how, say, the Americans are obliged to report gifts on a gift tax return. So an inheritance out of an actual bare trust, HMRC wouldn't necessarily know that you've received one. And presumably, unless and until via some exchange of information, CRS or FATCA, and HMRC find out about this trust and the distribution, they'd say, oh, actually, we take a different view. We think you should have reported this, and now we're going to hit you with penalties and interest because you haven't paid your tax. If HMRC don't hear about it, then they don't know what they don't know. And that is always, I presume, a struggle with clients, is that commercial decision of saying, look, on balance, we think this may be a bare trust. However, we think it may be beneficial for you to disclose to HMRC, because better to go in with clean hands than sort of sit on your hands and say, well, I'd rather just sort of take a punt, because in the future, HMRC probably aren't going to find out. But if they do find out, it's going to be a lot worse for you.
You're absolutely right. It is an interesting dilemma that clients face, and we as advisors face in doing the best for our clients, because you're absolutely right. Yes, going in with clean hands is really crucial. And otherwise, you are very much relying on HMRC accepting that you had a reasonable justification for believing this was a bare trust. So at a very minimum, if you weren't going to go in and disclose to HMRC, you would want to have sort of formal written advice that you could provide if required that says, yes, you've asked someone to have a look at this for you. There are reasonable grounds to believe this is a bare trust, and it's not unreasonable for you to report accordingly.
I wonder if we could find a UK lawyer that could advise on whether it's a bare trust or not. I wonder.
I couldn't possibly say there, Aidan. Do you know anyone?
I could give you some names, I think. So, looking in the time we have left at just a couple of takeaway points, a couple of things that people can think about to get the old juices flowing for, well, if people find themselves in these scenarios, what can we actually do about it? And breaking it down to the two camps that we've mentioned previously, before and after the grantor has died. While the grantor is alive, and while we still have the chance to carry out a full sort of amendment to the trust if we need to, what are some of the things that you recommend to people that they can consider doing, Gillian? Certainly from my perspective, distributions during the grantor's life, you've got a greater chance of getting a foreign tax credit under the double tax treaty. So if there are distributions to be made, think about making them during the grantor's lifetime. But also, with the acquiescence of the grantor, we may be able to amend the provisions of the trust deed to, as I joked at the beginning, sand down some of the rough UK edges. We turn those requests into demands. We take a look at the provisions of what happens if the grantor loses capacity, and we maybe sort of shave off some of the most egregious powers that the trustees take back. And then the record keeping, the part we mentioned earlier. Those, from my perspective, are some of the more common things we say to clients. Are there other things that you like to say to clients during the grantor's lifetime?
No, I think those are the crucial. Let's line up the foreign tax credits by making distributions during the grantor's lifetime, because the double taxation agreement covers that much more cleanly than when we are a significant period of time down the road from when the income and gains were taxed on the grantor. So that's a really great piece of advice. Increasingly, I am suggesting to clients that we look at modifications, best effort modifications, as far as is possible. In a couple of cases where modifications due to the wording of the original deed are no longer possible, we've found ways to completely start again. So that is always an option, and something that I do always explore with clients where I'm discussing the UK tax considerations with them, is sensible ways to bring the arrangement that exists at the moment. Is it possible to bring it to a close and perhaps put in place a different structure that achieves objectives from a US estate planning perspective, but is a bit more UK tax friendly? That is something that we discuss in the grantor's lifetime, because obviously this is the grantor's estate plan, and bringing them into the conversation and helping them understand the issues that we're grappling with is really important. And in a situation where the grantor is perhaps themselves thinking of coming to the UK, as early as possible, looking at the trusteeship, discussing with them during their lifetime whether it's right and proper for them to remain as trustees, if there's anyone else that they could trust and pass that responsibility on to that is remaining in the US and not becoming UK resident. Because I think one thing, just to close, that we didn't touch on is in that circumstance, you're potentially bringing that whole structure, if it is a substantive trust, into the charge of UK tax in its own right. And that stings. That's 45% straight off the bat and 20% minimum capital gains tax on everything that arises year in, year out. And with the best will in the world, and I'm sitting here as a tax consultant who files these returns, another piece of compliance that you've got to contend with every year. And who wants more tax returns in their life?
The point of the immigrating grantor to the UK leads me to what's probably the best piece of planning from a UK perspective, which is just to wind the whole thing up. If you're coming to the UK, and let's say you were coming to the UK for a degree of permanence, having a living trust in the US has a diminishing benefit once you're in the UK, because you're increasingly exposed to UK probate and also UK tax issues. So winding the trust up in a UK tax year before you come here, very importantly, this is ideally in a UK tax year before you arrive, means not coming to the UK with a grantor trust, and also means potentially uplifting all of your assets, getting a step-up basis in your assets for capital gains tax purposes in the UK, which is actually turning a curse into a blessing. The winding up of a grantor trust in the US can actually be, in the right circumstances, quite tax efficient. but you have to have the right circumstances for the right people. And and neither Gillian nor I are sitting here trying to drive a horse and cart through estate planning. We accept that if there is one UK resident beneficiary and half a dozen in the US, the apple cart is not going to be upset just for the sake of one beneficiary. It is about fitting the UK planning into the existing US framework and trying to offer suggestions as to how the UK tax might be ameliorated without absolutely turning over the US tax consequences for the remaining beneficiaries. Just looking very quickly at what if the grantor has died? What if Mr. and Mrs. Washington have died? And Martha has said, right, I am due to inherit out of this trust, but I'm aware that it's kind of crystallized the trust now because it is what it is. It's not to say there isn't anything we can do, but certainly many of the doors, the avenues get closed off to us. From my experience, it's really about ensuring the timing of the distributions works, because there is opportunity to decrease the proportionate tax charge that the UK beneficiary receives if the trust is all wound up in a timely manner, and we make sure that distributions to the US and to the UK happen in the same tax year in the UK, and that can be more tax efficient. And then also the appropriate analysis and tax reporting might mean, as I referenced previously, that we can get the income tax charge down to a capital gains tax charge, like I said, saving sort of 10-15%. But this is another reason why it's important to come to your advisors before the grantor has died, because those really are pretty much the things you can do. Most of the lion's share of what you can do happens before the grantor has died. Would you agree, Gillian?
I absolutely would. And that is exactly what we do end up focusing on. We end up focusing on quantification of the problem and looking at the residents of all the beneficiaries and looking at how we can time, as you say, the distributions to make things as efficient as possible. And you are really left with that being your focus. So I guess for me, the moral of the story is these arrangements should be reviewed on a regular basis to check that they still make sense for everyone involved, particularly where there is any possibility of anyone involved with the structure, either the grantor or a beneficiary, becoming UK tax residents.
Yes, absolutely. If this episode makes it over to the US and there are, estate planning attorneys and CPAs and the like listening to this, we're not saying don't have these. We're saying come talk to us. We're friendly. We're nice. We'll explain what the consequences are, and we'll try and guide you away from these pitfalls without tipping you into the US ditch on the side of the road. It's about creating a harmonious, tax-efficient estate plan that works across all the jurisdictions in which that estate plan has to work. So talk to us. Come chat to us. We won't bite, I promise. Gillian, thank you so much for joining me today. I hope you, the listener, found it enlightening, not too technical, and do come and see us if you have any of these issues. Gillian Everall of Everfair Tax, Aidan Grant of Collier Bristow. Have a lovely day.